A very good evening to one and all present. On behalf of Study Circle, I invite you all to the 94th meeting. Today's topic for discussion is a continuation of the lecture series, Art of Arbitration, and today's topic will focus specifically on setting aside of an award under the Arbitration and Conciliation Act. The speaker for today is Mr. G. Ashokapathy, Advocate, Madras High Court and an Arbitrator. I now invite Mr. Monish, Advocate, to render the welcome address and a brief introduction to the speaker.
Thank you, Ritika. Very good evening, everyone. On behalf of the Study Circle, I welcome you all for the 94th meeting. We have the benefit of Mr. G. Ashokapathy, Advocate, enlightening us on law of arbitration by a series of lectures. Today's topic is about setting aside an award. It is my bounden duty to welcome the speaker for today's session. The speaker does not require a formal introduction. Needless to say, the speaker of the day, Mr. G. Ashokapathy, is a senior member of the bar in the Madras High Court, carrying with him years of experience. He is also a renowned arbitrator by himself and also founder trustee of Seneca, an institutional arbitration center. Mr. G. Ashokapathy had been spending considerable amount of time for the cause of our participants in the study circle. With this, I now call upon the speaker to take over the session. Over to you, sir.
Thank you, Monish, for the nice address about me. And friends, today we are back on track with respect to the Arbitration and Conciliation Act on the lecture series. Today we'll concentrate only on section 34 of the Arbitration Conciliation Act, where we will be considering how to challenge an award and what are the grounds that are available for a person to challenge an award. Without much delay, we will straight away go into this section. I'm not going to read out the entire section as I've always not been doing it. Here in this section, we will have to split it into two different parts to understand this section in a better prospect. The first part of the section will deal about the party having to establish the grounds. And the second part will talk about how the court sees it in order to establish a ground for setting aside. So these are the two aspects relevant for the setting aside of an arbitral award. I would also like all the audience to think about one more aspect, that is, there are two more grounds under which an arbitration award can be set aside, that is under the Act itself, which are not mentioned in section 34 explicitly. So you keep thinking about what those two sections are. We will come to it at a later point of time. Now we'll go straight away to the section, what it talks about when it is to be established by the party to the arbitration proceedings, how the award is to be, on what ground the award is to be set aside. The first ground that has been mentioned is where the party was under some incapacity. What does this incapacity mean? I have to rely on Contract Act. A person of mental, not of mental soundness, a minor, or anything which is coming under section 11 of the Contract Act who are not competent to contract. So this can be said as a persons who are not in the capacity to contract. So those persons who are involved in the arbitration proceedings, if they are made as a party and an award has been passed, they can always come to the court saying that, look, I have been incapacitated, and in these circumstances, the award cannot be held to be valid. Now, the second aspect that is taken up is the agreement is not valid under the law. Now, what does this mean? The performance of an act which is illegal in nature, and there is a contract for that. Say, for instance, A wants to kill B and he engages the services of C, and there is a dispute between A and C with respect to this particular contract. We all know that it is a nullity. Such a nullified contract cannot be arbitrated. That is what has been specifically stated. An agreement which is not valid under law cannot be subjected to an arbitration. Thereafter, we have another section, another option is where the appointment of an arbitrator has not been intimated to the parties. Now, friends, we need to recollect section 21 of the Arbitration and Conciliation Act. When we discussed about the Section 21 of the Arbitration Conciliation Act, we were very particular about stating that this starts the initiation of the arbitration proceedings. In fact, that is the first of the lecture series where we spoke about Section 21. We said an arbitration proceeding starts by the issuance of this notice under Section 21. The most important aspects at that point of time when we discussed was it covers limitation, it commences the arbitration proceedings. Now, what relevance it has in this particular sub-rule is that if this commencement of arbitration is not intimated to the parties, then the entire arbitration proceedings is not valid and the award can be set aside. Now, when doing so, we need to understand what is the reason by which this particular provision has been made. In a Section 21 notice, we mention what are the references to arbitration that has to be made, who the arbitrator is going to be. Now, these two aspects are very vital for a person to object or concede to the arbitration proceedings. Let's assume that there is a contract, and in the said contract, if the parties are going to refer to a particular dispute which is within the framework of the contract, then such a dispute may not be objected. If, on the contrary, the dispute which is not within the framework, but it is between these two parties are referred to arbitration, then that should be put to notice to the other party who has the right of objecting it, saying that such dispute is not within the framework of the contract and it is not permissible for the arbitration tribunal to proceed. So when such thing comes in, such a incident occurs, the other party can file an application under Section 16 of the Arbitration and Conciliation Act. So a person to file an application under Section 16 or to know who the arbitrator is and to file an application under Section 12, he definitely needs to know who is appointed and what is the reference that has been made. You will also recollect, while going through under Section 21, we also said that the section requires that dispute which is referred to arbitration has to be enumerated. Though I had also stated the courts at present are taking a lenient view on that. Courts are not very specific on the fact that every particular dispute has to be mentioned. However, a broad outset has to be mentioned in these circumstances. So this now becomes very important. And if such a notice is not issued and an arbitration proceeding continues to go on, the award can be set aside on that ground itself. Next important aspect in the same provision is that the notice has to reach the parties. I'm not going to repeat on that because we have already seen what is the notice, how it is to be reached to the other party mean, that service is completion of service, all those aspects we have already covered. So we will not go in detail about it at this stage. So once the other party does not receive a notice, then he can raise a dispute or he can challenge the award. The next important aspect is in connection with the earlier 21 notice where the award is not within the terms of submission. So what are the terms of submission? As we already discussed, the terms of submissions are the disputes that are mentioned in Section 21 notice. So A says there is a contract between us. These are the disputes. A, B, C, D are the disputes that has arisen between us. So I want to refer these disputes to arbitration such that the respondent knows what is that he has to defend. Why is he coming to an arbitration proceedings? What he has to put forth to establish his case. So this is the basis of it. And that is why this has been made very important. And this is also important for another aspect because those terms which are referred to arbitration and other terms which are not referred to arbitration may also be lashed by limitation. So in such cases, later on, the claimant cannot sleep over and come there back and ask for a presentation of those claims which are not submitted to arbitration. So in such cases, the terms of submission shall not be beyond of what was actually submitted. Or there is another important aspect is the decision of the arbitrator is not within the scope of submission of arbitration. Now, what does this mean? This actually means that the scope of arbitration is limited. What can be arbitrated, what cannot be arbitrated, we have already discussed. Now, something which is not to be arbitrated, say for instance, an accepted matter. In a contract, generally these accepted matters are found in construction contracts or government tenders, where large-scale industries are considered, and they consider various other disputes. And one part of it, say for instance, it is pertaining to engineering calculations or working of a particular equipment that is made. All these things will require a technical know-how. So the parties may decide that an engineer or a chief engineer or some other person to be in charge for resolving such disputes. So those are accepted matters. So such accepted matters cannot be decided by the arbitrator, and it is not within the scope of the arbitrator to decide such matters. When such matters are decided by the arbitrator, then the award to that extent is set aside. When I say that extent, yes, the award can be severed in two parts: the scope where the arbitrator can arbitrate, and the portion which the arbitrator is not entitled to arbitrate. The doctrine of severability will be made applicable, and that portion of the award which is permissible will be taken into account, and that portion of the award which is not permissible will be removed or set aside. This is also provided in the provision to that same provision of section 34(4). Now, yet another important aspect is the composition of the arbitral tribunal. If the arbitral tribunal is not in accordance with the composition agreed by the parties, or if it is not in agreement with the with the provisions of the Arbitration and Conciliation Act, then such an arbitration award is liable to be set aside. Now, my friends, here we need to see one important aspect. This particular provision, by virtue of the judicial precedents, has become a provision which is not mandatory, and it is subject to section 4 of the Arbitration and Conciliation Act. In a case where there have been two arbitrators alone, or in a case where there are rules recommended, like the National Stock Exchange rules, which provides for two arbitrators alone, then such arbitration also has been held to be valid. The proposition accepted by the Honorable Court or laid down by the Honorable Court is that these provisions are not in consonance with the Arbitration and Conciliation Act. So the party should have raised such a dispute at the first instance under section 16, questioning the jurisdiction of the arbitral tribunal to proceed with the arbitration when the quorum is not in accordance with the act or in accordance with the party agreement to the parties. However, the same court says if the parties have not raised such objections, then it will be deemed that they have waived their right to object, and such an award passed by the quorum which is not approved by the act or by the agreement of the parties are held to be valid. There are two judgments which I would like to cite here, which is namely the Stock Exchange Mumbai versus Vinay Bohna and Narayan Prasad Lohia's case, wherein these two cases only two arbitrators had decided, which is not in accordance with the Arbitration Conciliation Act. We all have seen section 10 would say that it has to be in even odd number. However, even number of arbitrators were employed for appointed for rendering an award, and the same was held to be valid. Now, friends, with these aspects which have been narrated to you, one would understand that they all pertain to from the party's understanding. From the party has to give these information to the court. The party has to come forward and say that I was put under some incapacity. The party has to come and say, yes, we had agreed to our 3 arbitrators or 5 arbitrators, but a sole arbitrator had proceeded with it. So this award is not valid. I had objected to it at the right point of time, but still it was not considered. That can be taken up. The terms of submission was not had gone beyond, and the award has gone beyond the terms of submission. All these things have to be brought in by the parties to establish, and on the establishment of the same, the award is liable to be set aside. Now coming to the second part. The second part is with respect to the subject matter where the court has to find that these conditions are prevalent in the award, that these aspects are affecting the award, and in such cases, the award can be set aside. Now, what are these circumstances? Now, if you see that section, the court finds that the subject matter of the dispute is incapable or by settlement of an arbitration under the law for the time being enforced. Now, my friends, there is a subtle difference between saying that the dispute is not capable of being adjudicated by arbitration, and the dispute cannot be arbitrated. Where it cannot be arbitrated or where the parties have restricted the jurisdiction, that is coming under the first part A. And whereas in the second part, it talks about cases where the arbitration itself is not possible. Like for instance, there is a tenancy agreement. In the tenancy agreement, the arrears of rent is to be collected. Such a dispute can be referred to arbitration, and the arrears of rent can be collected. However, if the parties want to go for eviction, where the Tamil Nadu Recent Amendment Act of Rights and Obligations of the Landlord-Tenant Act applies, then in such cases, the Arbitration and Conciliation Act will not apply, and the arbitrator will be incapacitated to settle these disputes. So such a provision will come into play. Yet another important aspect in the recent MN Global case, where it has been held that proceedings which are governed by the DRT, Debt Recovery Tribunals Act, cannot be arbitrated. Earlier, there was a mixed opinion on this aspect. However, this has been clarified now, pursuant to Vidya Drolia and NM Global, that those disputes cannot be arbitrated. And again, we have right from SBB and then coming to other judgments where they have repeatedly said just in rem and just in personam has been distinguished. Where there's a case of rem, it cannot be arbitrated. All those aspects come within this purview of this aspect, this particular clause, and such an award which are passed, which the arbitral tribunal is incapable of, cannot be arbitrated. Again, we need to mention here about NM Global, where fraud, can it be arbitrated, was thoroughly discussed, and it was held that fraud can be arbitrated if the fraud is of minor in nature, if it is something which is to be punishable only under the, can be prosecuted only under the criminal law and not under the contracts, then it cannot be arbitrated. Now, there is a award where it is in conflict with the public policy. The major Pandora box lies in this public policy. Our act also contributes to some confusion. Apart from that, we have been having various judgments which have marched through the aspect of interpreting this public policy. We will go in detail with respect to this public policy and various judgments, how they kept on changing. I'm going to only cite those judgments and leave it to you all to read through the judgment, but I will give you all the crux of the judgment, what they ultimately found as public policy. That I will definitely go ahead. Now, what happened is, earlier it was just mentioned as a public policy. Then there was an amendment brought in to explain what public policy is. Actually, nowhere it has been explained, defined exact terms what public policy is. It was just left as public policy. Then an explanation was brought in only to avoid the doubts that can be brought in under public policy. And what explanation was brought in is, it said that making of an award was induced by fraud or corruption, or if it is in violation of section 75 or 81. 75 relates to the confidentiality of the arbitrator, or 81 with respect to the admissibility of evidence. So if someone had committed fraud or bias, all these aspects, corruption includes even bias. So all these aspects came into the aspect of public policy, and they decided such thing also came within the purview of public policy, and they cannot be arbitrated, and such an award has to be set aside. Then the next important clarification came in was it is in contravention, any particular award, if it is in contravention of the fundamental policy of Indian law. Now here this is important because especially in international law, international arbitration, what happens is certain aspects which are opposed to law in India would be a valid proposition outside India. So such award will be passed based on those laws. The substantial law of that particular country would have been accepted by the parties. Then the major contract would have been entered into and acted upon in the country of outside India. And for enforcement purposes and other purposes, they would come in here. Such award, how is it to be handled? Then they said, if it is contravention to the fundamental policy of India, then it is opposed to, it is also forming part of the public policy. Next important is the basic notions of morality and injustice. Friends, the very aspects, if you can see, it is very, very, very vague. Basic notions of morality and injustice. Of course, these clauses have been interpreted further to give it much more an inclusive meaning, and that we will be going through. Then explanation 2, which was very important to distinguish it from the international law, was brought in. And also for the very purpose that based on these public policy, a review on the merits of the dispute should not be conducted. So this was the basic importance for which the section explanation 2 was brought in. The idea behind this is, on the guise of testing the public policy, the court should not intervene into the arbitration award and go into the merits of the dispute and review the entire award passed. So that is not acceptable. So in that cases, so to make it clear, the legislature has made it that this should not be used as a spade to go inside the award and review the merits of the dispute. Apart from this, the yet another important aspects which is available for domestic arbitration alone is the ground of vitiated by a patent illegality appearing on the face of the award. So in this, what happens is, if the conscience of the court is affected, or if it shocks the conscience of the court, then such illegality is known as patent illegality, which is facing the award directly, and they come within the purview. However, as I told you earlier, there are situations which are valid outside the Indian law and which has to be accepted and followed while enforcing an arbitration award which is under an international commercial arbitration. So this particular explanation is available only for domestic arbitration, and it is not available for international commercial arbitration. So I therefore repeat the last one alone. An award which is to be challenged on the ground of patent illegality appearing on the face of the award will be applicable only for a domestic award and not for an international commercial arbitration. And furthermore, another proviso was subsequently inserted, wherein it said that the application shall not be set aside merely on the ground. Sorry, this is what I had earlier discussed. Excuse me on that. Now we will go to the various case laws that have been framed by the Supreme Court. Renu Sagar Power Company Limited would almost be one of the foremost case which spoke about public policy. As I told you, I'm not going to go in detail into the case law because each case law runs to various several pages, and explaining that itself would take the entire session. So what was laid down in Renu Sagar was that a fundamental policy of India, if it is affected, if the interest of India is affected, or if the award is unjust or questions the justice or morality, then it was considered to be coming within the framework of public policy. So three important clauses were brought in, namely fundamentals of public policy of India, the basic law of India if it is violated, the interest of the nation is affected, or in general it is very unjust or totally immoral, then it opposed to public policy. Now it was further discussed in ONGC versus saw pipes. And friends, what I'm going to talk to you all is the judgments which have been approved till date. I'm not going into the judgments which have not been approved, which have been subsequently not followed by the Honorable Supreme Court, especially in Sangyong case. ONGC versus saw pipes. Here again, fundamental policy was questioned, and they went through Renu Sagar also, and they said fundamental policy of Indian law if it is in violation, or the interest of India, justice and morality. All the three aspects which were already in Renu Sagar was again reiterated. In addition, they added if there is a patent illegality, then again it opposed to public policy. Now this was again approved in Hindustan Zinc Limited. However, they went one step forward and they said, they also brought these aspects that if the terms of the award is against a specific terms of contract, if it is not in accordance with the contract within the parties, then that would also amount to a patent illegality. So what has happened is what is available in the first clause B has been brought into in public policy also to an extent to say that if there is a contract and it is against that contract, this particular award is passed, then it amounts to a dispute on public policy. McDermott again, a very famous Supreme Court, which has been approved even till date, even in NM Global, it has been totally relied on. And wherein in the said judgment, Renu Sagar and ONGC versus saw pipes was approved. And the courts also went one step forward and said that intervention of court is envisaged in few circumstances only, like in the case of fraud or bias by the arbitrator and for violation of natural justice. So it cannot be in every other case that the court can interfere into an award. Again, it further said that court should not enter into the shoes of the arbitrator and correct the errors of the arbitrator. It is not the duty of the court to correct the errors of the arbitrator. It has to be put a full stop at that point of time. This was insisted on in Hindustan. Next comes the Centro Trade Minerals and Metals. In this case, what happened was the public policy was again taken up into consideration. And this is the place wherein they had brought in the aspect of shocking, which shocks the conscience of the court. Any act or any award which is so very absurd, it shocks the conscience of the court, then they say it amounts to public policy, opposing to public policy, and so it can be interfered. Delhi Development Authority thereafter came in. It said that it gave a decision that an award which is totally contrary to the substantive provisions of any law, which is nothing but against the law of the land, which is against the provisions of the Arbitration and Conciliation Act, which also is available in Part A of the said provision, or it is against the terms of the respective contract. That is, if it is not within the particular form of contract, within the ambit of the contract, or if it is patently illegal, or if it is prejudicial to the rights of the parties, it is open to be challenged under 34(2). The award has to be set aside if it is contrary to public policy, interest of India, justice or morality, and it also talked about the shocking of conscience. So in general, this particular case had narrated all the grounds which are available and summarized these are the only grounds in which an award can be set aside. The latest one is being PSA Sikal, which had come about, I think, 28th of July, where the question of how much an arbitral tribunal's award can be gone in through and can be considered for setting aside. This was considered, and where it says it is important that evidence, if an evidence is considered by the arbitral tribunal and it is not considered in the perspective in which it has to be considered, or if there is certain alterations made or award made in such a way that it was totally not contemplated by the parties under the contract, then such award is liable to be set aside. So where an award ignores the important evidence or makes an alteration in the contract itself, then such an award is to be set aside. This was recently held by the Supreme Court. Venture Global again spoke about various other aspects, such as saying that the court shall not go into an award and sit as an appellate court and decide on the case. In other words, the court has to go on the aspect of only within the framework as provided under Section 34 and not beyond that. Friends, pausing here for a moment, I need to explain certain other aspects which are mentioned in these judgments inside, like here and there they are mentioned, and which are also very important for us to understand. When there are two different opinions that an arbitrator can take, and if he has taken a view which may be larger in the larger perspective, very few take that view, still such a view has to be upheld, and it cannot be said that it is a minor view, so the arbitrator has erred in not taking the larger view. Such a thing cannot be approved, and the award cannot be interfered. Similarly, if the arbitrator has has come to a conclusion that certain provisions of law alone would be applicable for this present case, it has to be construed that he has gone through the entire facts of the case, and for his understanding and his way of judgment, he has gone through those provisions alone, and such an award cannot be set aside. However, if the arbitral tribunal has gone through the enactment, which is totally not applicable to the parties or to the contract in which the dispute arises, then such award has to be set aside. Friends, the latest, again, Supreme Court judgment in Sangyong Engineering, what happened was it approved Renu Sagar's case. It approved associate builder, where the conscience of the court has to be shocking, and if it is so, then it has to be set aside. Those things were approved. And it also explained when the award can be considered as patently illegal and it is shocking to the conscience. It says that when no reason is given for an award. Here, pausing a minute, friends, there according to Indian Arbitration and Conciliation Act, every award has to be reasoned. An unreasoned award can be passed only in a contract where the parties have agreed that they will accept an unreasoned award. In all other cases, the award has to be reasoned. If it is unreasoned, it is liable to be set aside. The other aspect is where the view of the arbitrator taken is impossible view for construing the contract. As I earlier stated, there is a particular contract. Within that contract, the arbitrator has to decide. If he takes a view which is not in any way connected with the contract, which is totally opposed to contract, then such a contract is not valid. Such a finding is not valid. For instance, in Sangyong itself, the core issue was with respect to the calculation of the compensation that was to be paid to the claimant. Though the contract specified a particular way of calculation, the arbitrators went through a different process which was not contemplated under the contract, which was introduced by NHAI subsequently by way of its circular and approved by the government. So they used such a calculation to calculate the compensation. This was not within the purview of the contract, and the Supreme Court had rightly said that such a view is totally not in accordance with the contract, and that's how the said award was set aside. An arbitrator has to decide on questions which are not beyond the contract terms and reference, which we had already covered. Those provisions which are not under those terms of reference which are not within section 21 notice cannot be decided by the arbitrator. And the perverse aspect has been taken up into consideration, and the court held if a perverse finding is arrived at the basis on no evidence, or overlooking a vital evidence, or based on documents taken as evidence without the notice of the parties. So what has to happen is, if it is a perverse evidence also, perverse finding, but if it is if it says along with the evidence that has been provided and based on the documents that have been provided, then such a finding cannot be overturned. But however, if the finding is considered to be perverse because no evidence was considered, or certain vital evidence was brushed away, then it amounts to opposed to public policy and it can be challenged. Friends, I had initially stated that there are two other options apart from what is stated in the Arbitration Conciliation Act under section 34, where an arbitration award can be challenged. I hope you would have gone through, thought about it, and I also wish that you would have understood where I am coming to. The important aspect here, what I'm trying to push before you all is section 13.5. I would like to recollect you all to section 13, which provides for the challenging of an arbitrator, where there is a independence or impartiality of an arbitrator as required under section 12 is in absence. A challenge to that appointment of arbitrator can be made under section 13. You will all recollect that such an application has to be decided by the arbitrator. He can either say accept, yes, I am coming within the purview of mischief of the act, so I am withdrawing my appointment. Or he can say, no, I am not within that violation, so I continue to be an arbitrator. In such cases, the parties on the passing of an award can use the same ground for challenging the arbitral award. So this is one example where you need not strictly stick to the provisions under section 34. You can also take in from 13.5 order and go for 34 application. Another aspect is when the competence of the arbitrator is questioned. The jurisdiction of the arbitrator is questioned under section 16. Similar to that of 13, here also when it is questioned, the arbitrator can recuse himself or he can proceed further. In such cases, the same position can be taken by the parties and an award can be raised, questioned under section 34. So friends, these are the grounds under which an arbitration award can be challenged. Now, having said this, what is the time limit for challenging an award has also been provided under 34.3. It says that a period of 3 months is available for a person to challenge an award. We all need to know that it is not number of days. They are specifically stated it is 3 months. So generally there is a misconception. It is 90 plus 30. It is not 90 plus 30. It is 3 months plus 30. Please count, especially when it is February. We generally miss out 90 days and we make a mistake there. So this has to be taken into account. What is this 30 days? So the discretion of the court is allowed to an extent of 30 days. So till 90 days, there is a clear time limit available for the parties to proceed. Beyond 90 days, if they are able to establish to the court that they were had sufficient reason for not being able to approach the court in time, then the court can extend the period of limitation for a period of 30 days and not beyond. This again, now from which date is to be considered? From which date does this 3 months to be calculated has to be taken into account, or will be based on the receipt of the copy of the award, or if there is a section 33 application. 33 is the provision under which an award has been passed. And thereafter, if the parties want to correct the award, or if they want certain, they find that certain errors have occurred in the award, then for correction of the same, the parties can approach under 33. After the passing of that order and receiving it, from there, say the 90 days starts from. Friends, I would like to place only 2 more judgments. One is with respect to the general aspect, as I earlier spoke also, that the court is not to sit as an appellate court and decide. And another important aspect is a remand when it can be made under 34(4). So when the question of remand comes in, general presumption is that we consider that all the moment the power of arbitrary court is vested with the power of remand, we think that the award can be passed, or the court can step in as an appellate forum and proceed with the arbitration tribunal's award and go ahead and remand, set aside everything. But it is not so. There are 2 judgments which I would like to place. One is Quality Manufacturing Corporation and Kinari Mullik and another. In both the cases, the Supreme Court has held that the under section 34, the court is not to be treated as an appellate forum, and what has to be remanded is only the portion where there is an error, which is, if left alone, would be requiring the court for a set aside of that award. In order to rectify that defect, the court can stall the proceedings as it is and remand the matter to the arbitrator to rectify that error and send it back. Now, to explain it in detail, let's assume that there are about 5 issues which were raised and to be considered. The arbitrator, by oversight, omitted to consider one particular issue. Then the award is challenged, stating that this arbitrator has not considered all the issues, and it is not in accordance with the submissions of reference. In such cases, to negativate the dispute or negativate the ground, the court can refer the matter back to the arbitrator and ask the arbitrator to address on the said issue, and thereafter remand it back, send the papers back to the High Court, as the case may be, for adjudication. So the remand is only to that extent and not beyond. Friends, there is also another provision under the in the said section 34(6), which gives time frame for passing dealing with an 34 award, 34 application. It states that it is 1 year, and what is more important is the section says it is 1 year from the date of an service of the notice under subsection 5. What is subsection 5? When you file a petition under 34, you have to intimate the other side that I'm going to file a petition under 34. Now, if you take that into consideration, what happens in reality is I may file an application, want to file a petition under 34, today being the date on which I received the award. I would have filed it. I would have immediately served a notice also on the other party. I will wait for 3 months and then file the application for setting aside under 34. It will take about 1.5 years, 2 years also, God knows, it will get numbered. Now, what is the sanctity of this 1 year from the date on which I serve a notice under section 5, subclause 5? I can understand if it's said from the date of it numbering and coming to the court or the court admitting, because today it is necessary that a 34 has to be admitted and an admission process is involved. From that date onwards, if it was 1 year, it would have been more sensible. This particular section, as it is, has not been rightly framed, and it is totally not futile. It is futile in this particular purpose. So with that, friends, I have covered section 34, and I'm open to all of you all. If you have any questions, we can go ahead with that.
Thank you. If the participants have any questions, they can either post that in the chat box or they can use the raise hand option. And I see Suresh sir has a question. I've unmuted you, sir.
Good evening, Ashok.
Good evening, sir.
That was an excellent session. I was listening to you for some time today. I have to be honest. See, I have a basic question. See, I am I'm a claimant in an arbitration proceeding. There is an award which is not enough for me, and I'm going to contest. That claim amount is being sent by the opposite party. If I'm going to contest the award, can I receive without prejudice and contest? Or what is your opinion? Or should I return that?
Sir, first and foremost, do you think that your case will come within the purview of the grounds under 34? Yes. Because we need to, if it comes within that purview, then we next need to see whether that particular act of receiving, will it nullify that ground? If it doesn't nullify, and if you can still proceed with that ground as it is, then I don't find any reason why you should not receive it, because that is something which is not challenged by the other side, presumably, and he is going to give it. There's nothing wrong in it. But if the other side is going to challenge it, then there's a different provision he is not going to give. And if the receipt of the amount going to affect the entire process itself or the ground that you are taking, then you may not be entitled to take.
Okay. The other one is now this limitation periods is on and off being extended by the Supreme Court, various things. See, for example, I have conducted an arbitration proceedings during the pandemic period, where the limitation period was extended time and again. During that period, an entire arbitration proceeding is conducted and award has been passed. In such a situation, from when the limitation point starts?
Sir, that is still going to be a very gray area, because Supreme Court has now and then extended time. So what is happening today is everyone who has lost their time also have gained it, and they are filing everything, and all that is required by the section also is one paragraph stating that it was due to pandemic, we are coming at this point of time. If that is said, they are also numbering. That is how it is going on as of date. So unless otherwise court comes and says this is genuinely affected by pandemic, and so, and I also do not know how they are going to have that yardstick. It's going to be a tough thing to judge. Honestly, honestly, that's all I can answer. Like today, that is the situation.
I have to be honest to tell you that this question I'm asking in a particular case, it is for me, but I'm asking for the other side. Thank you, Ashok. Thank you.
Okay.
I just wanted to have two queries.
Yes.
Before that, I think Haripriya has raised a hand, so let us hear us.
Yes.
Good evening, sir. I have a doubt.
Good evening. Yes.
So, if the arbitrator decides on a matter in which criminal proceedings could have been filed against the respondent, can that be a ground to set aside the arbitral award, sir? Because it is beyond the term. It's not an arbitrable issue. Can we claim it that way, sir?
So let me understand your question. You are saying that one of the issues in the arbitration, he says that it is to be decided by a criminal court, and hence he doesn't decide on that. Am I correct? You can unmute her.
Yes, sir. So, the criminal charges could have been filed against him, but that also comes under the breach of contract issue. Both are possible. Yes.
So what NM Global now has clarified is if the act of the party has to be considered only under a criminal proceedings, then such a issue cannot be decided by the arbitral tribunal. However, if the same can be amounted to a question of damages and claimed under the contract itself, then such decision, such an issue can be redressed by the arbitral tribunal. Say, for instance, where they were questioning about the fraud. Fraud is dealt with under contract also, and also under the criminal procedure. If a person has committed fraud and based on that a loss has occurred and you can proceed with it, you can still proceed with that in civil manner. In other words, what the court has said is if a civil court can entertain the fraud on a contract basis, then it can be arbitrated. Hope I have clarified your question.
Mr. Ilangovan has a question. I've unmuted him.
Yeah.
Sir, good evening.
Good evening, sir.
It's a wonderful session to hear.
Thank you. Thank you.
Sir, my question is, sir, in respect of all the judgments, while defining the public policy, the words are used as absurd, perverse, unreasonable, irrational. Sir, how to interpret these kind of words in a plain language or each and every circumstances of the case, which gives rights to this kind of things? Public policy is covered with so many words. How can we fit into each and every facts and circumstances of the case while applying these things?
Yes, the basic important aspect is, as the famous wording of Justice M. Sundar, we can't bring in the pigeonhole theory here for public policy. You can't put everything into a particular pigeonhole and say this comes into this jacket, I'm fitting into it, so this comes to public policy, opposing to public policy. So that is why it has been stated that it's a very, very, very narrow aspect. It has to be interpreted from case to case, and a general presumption cannot be made for analyzing a public policy. And even a word or two which gives an outer scope, our courts are criticized left, right, center internationally for opening the Pandora box of public policy. So in fact, when ONGC saw pipes came in for the first time, I mean, when it was pronounced, internationally, they said India has opened the Pandora box, and it is a country which is not fit to have an arbitration conducted. All these things were remarked world over. In all the conferences they started making, especially the conferences which were held in Asia and Asia Pacific, where more of arbitrations were involved in that, they started saying that. As a matter of fact, most of the words which are used under the Act and as well as by our judges are also prevalent in other international judgments. However, the slight difference also makes a vast questioning power of the court. Internationally, what it is considered is an award should not be allowed to be challenged, because an award is something which the parties have consented for themselves to have it from particular person known as the arbitrator. So once the person passes it, the concept of arbitration is that you shall not challenge it. That is why if you see the 34 Act also, provisions also, it gives only on worse scenario like corruption, like those which are not referred to. All the extreme circumstances only will be mentioned. So that is why even when defining public policy, the courts have taken all pains to see that it is narrowly defined and not exhaustively defined. So that is why it is all mentioned. So it has to be worked out on the case to case. In fact, my opinion is the aspect of subjecting it to the shocking of the conscience of the court itself is a very, very far-reaching provision, which should not have been made, in my opinion, because what shocks to me will be something which I see for the first time. It will definitely shock me. For another person, it might be an everyday affair. So I may have a different opinion and he may have a different opinion. So such is the provision. That's a very vast provision that has been given. So as it is with this limited words itself, we sometimes feel that more powers are given under the framework of public policy. That is why it has been restricted.
So can I ask you another question, sir?
Yes.
While you were telling about the Sangyang judgment, there was reference to the evidence. You said that no evidence was considered or important evidence have been left out. And another aspect is the interpretation of the evidence, reappreciation of evidence. Now, if there is any distinction between these three words, and while the appreciation will be always there, what are the evidence which has been left out? It can be pleaded at any time, saying that my evidence is like this and he should have taken this kind of view. How you see these three things, sir? No evidence, important evidence left out, and reappreciation of evidence. And whenever we go for a challenge, they say that we cannot reappreciate the evidence. And we can say that it is an evidence which has to be looked into for set aside this award. What is your view?
So, it is quite simple here. We need not look at from the aspect of a civil court and understand the phraseology looking into the evidence. So what has to be done here is under 34, the power of the court is only limited to the extent of saying that here is an evidence which is vital, which was produced before the tribunal, which the tribunal has not chosen to go through. I'm not saying that he should have gone through and passed this award in this manner, all those things. It has to be very vital, very important. If the arbitrator has recorded the evidence, that is sufficient that he has considered it. He need not even give a finding. If he has recorded that evidence also is sufficient. But if there is a case where I have produced it, still he has not recorded it also, and he goes to the extent of just ignoring it from the inception of it, or he goes totally diagonally opposite to it, which no person can outside appreciate at all. Like for instance, saying the evidence says that A has to give money to B, but he reads it as saying that B has to pay to A, and he passes an award. That is improper appreciation of evidence. That is only that aspect can only be brought in before the court, and not every other aspect of as which we will do in a first appeal. That is not available.
Thank you, sir. Thank you. Thank you so much for your clarification.
Probably finally my question, consequences of setting aside section 34. You will need to cover in a separate session or something can be added. Because there are you award is set aside, you fail, award is set aside, but what next is a big question, which is like.
Yes, what happens is in many cases, the court can either say it is set aside on technical aspect, like for instance, limitation and all those things. If it is set aside, award is set aside, then it is an end to it. But where it is on merits, on certain irregularities that has been conducted, if the arbitrator was incapacitated or there was a bias, and then in such cases, the award will be set aside. It will be left to the parties to initiate the arbitration proceeding de novo on a fresh inquiry. So that is available as it is. In a recent judgment, of course, in PSA Sikal, I don't know, the court had gone through the entire judgment And they said that this particular way of proceeding for valuation of the acquisition of land is not valid. It is opposed to public policy. They wanted to set aside the award. They set aside the award. But however, having said all those things, under 142, Article 142, they interfered. And they said only till this portion it is having a precedence, and the last portion will not have a precedence. It is only for this particular case. So under 142, they entered into and they approved the aspect of giving compensation, and they passed the award, rewrote the award itself. However, yes, they themselves have stated that court cannot interfere, but however, it gives an impression now for everyone to say that if I want to get the award rewritten, I need to go to the Supreme Court, where they will have the power under 142, Article 142, and rewrite an award. But basically, your question is, yes, it will be set aside and de novo inquiry can be conducted. His Lordship Justice Nariman had stated, if I'm going to send it back, it has already taken 7 years, and it has been by an arbitrator who is appointed by the government, who is again going to be very cynical in his approach. So there is no use of sending it back. So I'm passing this. That's how he has come to that conclusion. It is not basically at the outset. It is morally, it is excellent judgment. But then when seen from the eyes of the law set by them, I find some contradiction there. But anyway, it is Supreme Court's judgment, and the court also has bifurcated its own judgment. Last 2 paragraphs, it has said it is not coming under, and it has also relied on another Supreme Court judgment. I'm not able to immediately recollect for passing such an order.
Thank you, Ashok. Thank you.
There seems to be no further questions for the speaker. I thank the speaker for taking his time out for giving us this lecture today as a part of the larger series, The Art of Arbitration. It has been a very informative series combined with the interactive Q&A post every single session. I would like to thank the organizers for having organized this lecture series for the benefit of all the participants. Finally, I would like to thank the participants for joining us today and in all of these sessions. Thank you.
Thank you.